Good afternoon. I'm Ann Rector, the director of the legal writing courses here at Emory Law. Welcome. Thanks for coming. Yeah, I know it's required, but thanks anyway for coming. Speaking of required, if you did not sign in on your way in, there are sign-in sheets out on tables right outside the auditorium. Please do that when you leave so we know you were here, since we're taking attendance. Also, you should have a handout that gives you information about what you're about to see and also some guidelines about how to look at it and how to observe. So if anybody's missing that, if you put a hand in the air, we've got some copies we can hand out right now. Got somebody down here. There are probably others who don't want to admit it. We've got somebody over here. All right, okay. Simple stuff. You can also share with a neighbor. I'm sure they'll share. So, little housekeeping stuff. If you would, please close laptops, put your phones on silence, that sort of thing. This should be approached as if you're in court, because that's what we're demonstrating, an oral argument at the appellate level. And this has been part of the legal writing program since about 1998, because our philosophy is that we demonstrate, give you samples, give you things to go by, give you experiences before you have to do it yourself and before you get it graded on what you do. So this is a continuation of that model. We're going to show you an outstanding, appellate oral argument, and then you'll get to practice your own, and then you'll get to do one the weekend after this. Woohoo! Yeah, it's exciting. I myself was terrified, and I won't even go into war stories, but I was. So please be attentive, courteous, respectful, the way you would be if you were in courtroom. We will have presentations by the criminal procedure team, Moot Court Society special team, and folks from Moot Court will be telling you more details about all of that. And then afterwards you'll have a chance to ask questions, if anybody's brave enough to do that here in front of everyone else. If not, you can always ask your professor, or ask the team, or ask the Moot Court folks who are here. And then we'll have a few wrap-up announcements, and we'll see how fast we get out. So, I think at this point, looks like most folks are in here. So I'm going to turn this over to the Director-in-Chief of our Moot Court Society, Daryl Ambrosini.
Thank you, Professor Rector. And congrats on all 1Ls for turning in your brief. I still remember what a huge relief that was my first semester and being able to go off on spring break right after the brief was due. So congrats on that. And now you get to look forward to the thing that at least everyone on this stage finds as the most exciting part of LRAP, the oral arguments. Now, before we have one of our teams perform for you, I just want to tell you a little bit about Moot Court and oral arguments generally. So to start off, let me answer the main question everyone has about Moot Court. What's the difference between Moot Court and mock trial? Well, mock trial is the trial stage, and Moot Court would happen after mock trial. So we do the appeals. Unlike mock trial, where you argue the facts of the case, Moot Court, you argue the law in front of 3 circuit court or Supreme Court judges who decide your argument and rule in favor for or against you. Often the legal issues argued in Moot Court are those that the real Supreme Court has, and the team that you'll see shortly, the Gibbons criminal procedure team, both of their arguments that they'll discuss today were argued before the Supreme Court this past fall. Now, at its core, Moot Court competitions are kind of like a high-stakes LRAP. Unlike going at it alone and arguing only one side of the issue, in Moot Court, we have teams comprised of 2 2Ls and 2 3Ls, where the 2Ls will compete as a team and together write one brief and do oral arguments. Unlike LRAP, where you only argue one side of the issue, we argue both sides of the issue in consecutive rounds. Having competed myself, I can assure you that it really is an exciting experience. Now, to tell you a little bit about our society, we're composed of 71 members currently, 35 2Ls and 35 3Ls and 36 2Ls. The 2Ls compete, and on your 3rd year, you coach the team you competed this past year. For example, I was a 2L competitor at the Gibbons criminal procedure team and did this demo last year, and this year I'm coaching Sarah and Amelia. In addition to the criminal procedure team, which goes to scenic Newark, New Jersey this weekend, We also have teams that compete at entertainment and communication law competition, a securities law competition, immigration, bankruptcy, labor and employment law, and those all go to New York City, almost as good as Newark. We also attend sports law competition and an international law competition in New Orleans, a First Amendment competition in Nashville, and ABA's competition in Washington, D.C. Additionally, we send 2 teams of 3Ls to a national competition in New York City, where 2 years ago we finished 2nd place overall in the country. And this year, we also sent a team to the national championship in Houston for being ranked the 16th best moot court society in the nation. Now, one last thing I want to tell you about the society is that we're entirely student-run, from going to competitions to hosting our own competition in the fall. So this whole demo, with the aid of Professor Rector and the LRAP teachers, is brought to you by the Moot Court Society, and Sierra Logan, who will be speaking shortly, will be your point person for the 1L competition. Now, on a personal note, I just want to say that Moot Court was one of the best experiences I've had in law school, from honing my legal writing and research skills to meeting a great group of people that all share the same interests. Pretty much everyone on Moot Court is a very outgoing group of people. We like speaking in front of people and arguing, so it's actually a really fun time. So I highly encourage all of you to try out for the society. Sierra will give you all of the details, but it pains me every year to see 1Ls not sign up to do the Moot Court competition, and then after going through the LRAP oral arguments, you realize you actually enjoy it, and then it's too late to sign up. So I urge you all to at least sign up, try it out, and see how it goes. And with that, I wish you the best of luck. I'm going to hand it over to Sierra Logan, our Director of Intra-Schools Competitions. Sierra will be your point person for all things related to the 1L competition, and she is going to introduce the demonstration. Thank you.
Hi, everyone, and again, welcome. My name is Sierra Logan, and I am from scenic New Jersey, and I will be leading this 1L Moot Court competition this spring. We are so very excited to get to know you all through this competition, and we're also excited to show you all what an oral argument looks like. Before we begin, I want to say a few words about what you all are about to see. Before you, we have 2 Moot Court Society members that compete at our annual Gibbons Criminal Procedural Competition, Sarah Josie and Amelia Todd. These 2 will go to their competition this weekend, so this audience will serve as great preparation. In Moot Court, usually there are 3 Supreme Court justices. Our Supreme Court justices for today are our Director-in-Chief, Daryl Ambrosini, Nick Anderson, and Kedar Mehta. Daryl and Nick are coaches for the Gibbons team, and Kedar Mehta is a coach for the Cardozo Entertainment Law team. Today, I will serve as your bailiff. Today, Sarah and Amelia will argue for the respondent, the United States, because that is the side they have been assigned to write their brief on for their competition. They will each argue a separate issue on the respondent side. In Moot Court, there is typically a petitioner and a respondent. The LRAP oral argument will be a bit different in the sense that there will be an appellant and an appellee on the same issue. But here, we have 2 separate issues on one side. And I'm explaining this to you so that you don't get confused when you all argue for your Moot Court competition. You will argue one side of a singular issue, while a classmate will argue the opposite side for that same issue. We have distributed a mini bench brief with a summary of the facts and question presented. Today, there are 2 Fourth Amendment issues before the court. For the first issue, Sarah will argue that though evidence from an investigatory stop of Mr. McLean was based on a mistake of law, the evidence should not be excluded. For the second issue, Amelia will argue that a dog sniff was not an unconstitutional seizure, but a reasonable stop. Without further ado, we will begin. All rise. Oyez, oyez, oyez. All persons having business before this court, the Honorable Court, are commanded to give their attendance, and they shall be heard. The Supreme Court of the United States is now in session. The Honorable Chief Justice Ambrosini, Judge Madar, and Judge Anderson presiding. The first case on the calendar is the case of Ben Harmon versus the United States.
Respondents, are you ready?
Yes, Your Honor. May it please the Court, Mr. Chief Justice, Your Honors. My name is Sarah Josie, and along with my co-counsel, Amelia Todd, I represent the United States, the respondent in this case. Today, we respectfully ask this court to affirm the holding of the 14th Circuit Court of Appeals. My co-counsel will discuss why the delay in order to perform the dog sniff was reasonable. But first, I will discuss why there was reasonable suspicion here for an investigatory stop. Here, Officer McLean had reasonable suspicion that a law had been violated. Officer McLean's mistake of law can support reasonable suspicion for an investigatory stop for 3 reasons. First, Officer McLean's investigatory stop of petitioner's vehicle was objectively reasonable based on the reasonable suspicion standard. Second, a police officer does not need to conduct a full legal inquiry when she reasonably interprets a law in the course of her duties. And finally, evidence from an objectively reasonable investigatory stop should not be excluded. To my first point, the stop was objectively reasonable based on the reasonable suspicion standard. This court held in United States versus Knights in 2001 that the touchstone of the Fourth Amendment is reasonableness.
Counselor, how is it reasonable for an officer not to know the exact law of the jurisdiction it's meant to uphold?
Your Honor, in this case, this was not an ignorance of the law. This was a reasonable mistake of law based on Officer McLean's training and experience. This concept of reasonable suspicion is not a neat set of legal rules. And this court has held in United States versus Arvizu in 2002 that officers are allowed to draw on their own training and experiences to make inferences from and deductions about the cumulative information available to them.
Isn't this really, though, Officer McLean's lack of experience that led her to not know the law?
Your Honor, the record is silent on page 1 as to whether Officer McLean had any specialized training. However, we do know that she went through the police academy, and she has this specialized training that doesn't require her to be a lawyer. She's not a legal technician in that sense. The Fourth Amendment requires our government officials to act reasonably, but does not require perfection. We give our
So it's okay for officers just to pull people over for doing things that are illegal?
No, Your Honor, that is not what we are arguing today. But it is all right for an officer to have a reasonable mistake of law based on the totality of the circumstances. This court held in Brinegar versus United States in 1949 that officers are given fair leeway for enforcing the law in the course of their duties. The Fourth Amendment does not require a policeman who lacks this precise level of information to pull someone over to simply shrug their shoulders and walk away when a crime may be occurring. Under the doctrine laid out in Terry versus Ohio in 1968, police can stop and briefly detain a person for the purposes of investigating. The reasonable suspicion rule allows for a temporary seizure if specific and articulable facts, along with the rational inferences from those facts, reasonably warrant this type of intrusion.
What were the facts here that led to Officer McLean pulling over Ben Harmon?
Your Honor, as you will see on page 1 of the record, Officer McLean was doing her job as a patrol officer on the highway. Ben Harmon drove by looking very suspicious, gripping the steering wheel.
Where was he grabbing or gripping the steering wheel?
He was gripping the steering wheel very tightly at 10 and 2 o'clock, Your Honor.
Is that normal to be gripping at 10 and 2, Counselor?
Based on Officer McLean's training, when she viewed Ben Harmon driving down the road, he looked suspicious and was gripping the steering wheel very tightly. However, she did not pull him over right away. Based on her observations, she pulled out behind him, and when he stopped on his brake, she noticed that one of his brake lights was out. That was when she pulled him over just to give him a warning citation and let him know that one of his brake lights was out.
But technically, he wasn't breaking any law for having one taillight out, correct?
Correct, Your Honor. The statute is quite counterintuitive and confusing, however, and this court takes that into account when analyzing whether a mistake of law is reasonable. The statute in this case has two parts, one requiring a stop lamp and one speaking of all brake lights. The statute in this case is clearly counterintuitive, as a car is equipped with two brake lights for a reason.
But don't motorcycles only have one? And that's okay.
Yes, Your Honor, a motorcycle is only equipped with one brake light, and a motorcycle is much smaller than a car. However, in this case, the car was equipped with at least two brake lights, and one of them was out. Officer McLean was perfectly reasonable in pulling Ben Harmon over to let him know that he had one of his brake lights out. What is generally demanded of our officers in these situations is not that their factual determinations always be correct, but just that they always be reasonable.
Shouldn't officers know the law fully before being sent out to uphold the law?
And going off of that, shouldn't we hold them to a higher standard even than we hold average citizens?
To your first question, Justice Ambrosini, officers are not legal technicians. While they are required to know the law, they cannot be required to interpret it so distinctly in the course of their duties. And Justice Anderson, officers are not held to a higher standard. They are police officers, but they are also not lawyers. And this court held in Ryburn versus Huff in 2012 that courts assess police judgments from the perspective of a reasonable officer on the scene. We can't use 20/20 hindsight vision here to think of what Officer McLean could have done.
So even if we decide not to punish Officer McLean for pulling over Ben Harmon, shouldn't we still exclude all evidence found in Ben Harmon's car after the fact?
No, Your Honor. Evidence from an investigatory stop that is based on an objectively reasonable mistake of law should not be excluded. This court held in Herring versus United States in 2008 that suppression of evidence is warranted only when the police exhibit deliberate, reckless, or grossly negligent disregard for Fourth Amendment rights.
How is this not negligent? I just don't understand how an officer that's supposed to uphold the law doesn't know the law fully. I'm not saying it's deliberate and he pulled him over for some reason he shouldn't, but shouldn't an officer know every law to a T of, he was a traffic cop. She was a traffic cop after all.
Yes, Your Honor. This was not an ignorance of the law situation. Officer McLean did not know the law. This was just a reasonable mistake of law based on balancing the public safety concerns of society.
I feel like that's just mere semantics. I mean, you're saying, oh, well, it's a mistake, it's not ignorance, but I mean, what's the actual difference?
Your Honor, the difference is that Officer McLean can reasonably interpret this law in the course of her duties. She's not a legal technician, and she has to make quick second decisions based on her reasonable assumptions at the time. And it is perfectly reasonable for a police officer to see someone with their brake light out and to pull that person over just to let them know that their brake light is out. This court has held that exclusion should only apply to not deter objectively reasonable law enforcement activity. This court held that in United States versus Leon.
Doesn't this just allow officers to pull anybody over if they think they're suspicious but not enough suspicion so they just say that there was a law broken?
No, Your Honor, not at all. What is required is reasonableness. And officers are not required to be perfect. However, we do require reasonableness. And this case can contrast with Delaware versus Prowse in 1979, where the police officer testified that he saw no traffic violations, no equipment violations, and he simply pulled the individual over to check his driver's license and registration.
And what court decided that case?
This court decided that, Your Honor, in 1979. And in that case, this court held that that was a violation of the defendant's Fourth Amendment rights. The foremost method for enforcing traffic violations is acting upon these observed observations that police officers make every day in the course of their duties. It's impractical to believe that a police officer can always clarify her understanding of the law in the course of her duties. When Officer McLean saw a malfunctioning brake light, she recognized that it posed a risk to other drivers on the road. This court has consistently given officers flexibility in upholding the law. This case compares with a very similar case from the Eighth Circuit, United States versus Martin from 2005.
Okay, but why should we follow an Eighth Circuit case? I mean, it's not binding on us.
Your Honor, the facts in this case are so similar, and it's quite a compelling holding that the court held. The statute in Martin required that the vehicle be, quote, equipped with a stoplight in good working order. The Martin Court recognized that a misunderstanding of traffic law, if reasonable, need not invalidate a stop on that basis. So the court's reasoning in that case is quite persuasive for this court. The actions of the officer in that court were held to be objectively reasonable. Evidence should only be suppressed if it can be said that law enforcement officers have knowledge or may have knowledge that the search itself was unconstitutional. Here, Officer McLean reasonably believed that her search was constitutional and that she was not violating Ben Harmon's Fourth Amendment rights. This case compares with Michigan versus Del Filippo in 1979. The court found that the search involving an arrest based on an officer's reliance on an ordinance that was later declared unconstitutional was valid. And the court found that the evidence did not need to be suppressed.
Counselor, I have policy concerns here. It seems as though legislatures can write broad laws that police officers can interpret whatever ways they really want to, because there isn't, then they can make the reasonable mistake as you claim. So doesn't this just add to police officers being able to interpret whatever they want, because legislatures can continue to write broad laws?
Chief Justice, I see my time has expired. May I please answer Justice Maeda's question?
Briefly.
Your Honor, the policy concerns in this case are more considering drivers on the road. We want to think about just this statute rather than broad statutes in general. However, police officers can only interpret laws reasonably. We're not saying that police officers can interpret any law any way they want. Thank you.
May it please the Court, Mr. Chief Justice, Your Honors. My name is Amelia Todd, and I also represent the United States. Today, we respectfully ask this Court to affirm the holding of the 14th Circuit Court of Appeals. The 7 to 8 minutes between the time Officer McLean issued Mr. Harmon a written citation and the dog sniff was reasonable and de minimis. Those 7 to 8 minutes were reasonable because, first, it was a second stop, not an unconstitutional seizure. And second, that stop is reasonable according to Terry's two-part test. And to my first point, this was not an unconstitutional seizure, but a very reasonable stop. In Illinois versus Cabayas, this court said that when a traffic stop ends, it ends when that warning citation is issued. And whenever a traffic stop turns into a drug investigation, there must be reasonable suspicion for it.
Did the police officer make clear that there was a second stop in effect?
Yes, Your Honor. And according to the record, at about 20 minutes, the Officer McLean said that all business related to the traffic stop was over.
What factors created reasonable suspicion here after the traffic stop was over to still hold Mr. Harmon?
Yes, Your Honor. So Terry gives us a reasonable suspicion standard, and United States versus Cortez says that there must be a totality of the circumstances test. So those factors would be Harmon and Morgan, his passengers' nervousness when speaking to Officer McLean, their very anxious and stiff behavior. One was smoking, the other was driving very stiffly.
They just got pulled over by a police officer. Is it really that unreasonable that they're nervous?
Your Honor, yes, it is. It can be a pertinent factor in reasonable suspicion. Nervous and evasive behavior and avoidance of eye contact were both held as pertinent factors to reasonable suspicion in Illinois versus Wardlow in this court held in 2000. Also, there was an overwhelming scent of air freshener when Officer McLean when she approached the vehicle.
Okay, so is air freshener, though, I don't understand how that can really be that suspicious. I mean, lots of people have air freshener in their cars.
Maybe he smelled bad.
Fair.
Well, Your Honor, and Justice Maida, that could be true. But Justice Anderson, in Officer McLean's experience, she is allowed to, according to Terry, make reasonable inferences from her training and field experience and her observations in the moment in the field. And in her experience, air freshener had been used as something to cover up the scent of contraband. And also, the Fourth Circuit in United States versus White has said that the overwhelming scent of air freshener is a pertinent factor.
How much weight can we really give to the experience of this individual officer, considering we don't really know if this is necessarily a good police officer? Like, her experiences may have been bad, for all we know. So is it really fair for us to give that much deference to that?
Your Honor, Yes, we should give deference to Officer McLean in this case. Reasonable suspicion is a very low bar, and according to Terry versus Ohio, which is the standard for reasonable suspicion, officers should have specific articulable suspicions, and they are allowed to make reasonable inferences based on their training and observations. Otherwise, it's a slippery slope if we do not allow them to.
But isn't there a slippery slope the other way? Say I like the smell of ocean breeze and I'm driving my car and I get pulled over. Obviously, I'm going to put my hands on 10 and 2 and be nervous wondering why I got pulled over. Am I automatically suspicious to any officer if I have air freshener in my car, holding the wheel where I'm supposed to, and have a passenger smoking a cigarette?
Your Honor, you may not be, but in this case, Officer McLean reasonably suspected that Mr. Harmon was. And this court held in United States versus Socolow that factors that are seemingly innocent can be allowed to be used in that totality of the circumstances test. So they can amount to reasonable suspicion, even if by themselves they seem innocent. So here there also were a few other factors. Their reason for traveling a long distance in the middle of the night was very improbable. They said that they were coming back from seeing a vintage car, and it was the middle of the night, and they had no evidence of that car. The circuit courts in the 10th and 8th circuits in United States versus White and Riley have said that that's a pertinent factor, those implausible reasons. And like,
but it's an implausible reason. I mean, here they went to go buy a car. They didn't like the car, so they didn't buy it. I mean, what other evidence would there be?
Well, Your Honor, in those cases, the situations were individuals telling officers seemingly fine stories on the surface. They weren't completely bizarre, but as the officer investigated further, they just didn't line up. And we have to be able to trust officers in those ways. Traffic stops with longer periods of time have been deemed reasonable. In the 8th Circuit and in the 4th Circuit, in United States versus Foley and United States versus Branch, courts have held that a 30-minute detention, which was about the time of the total stop.
Counselor, if the 4th Circuit and the 8th Circuits want to disregard the Fourth Amendment, that's fine, but this court doesn't plan on doing that.
Okay, so in United States versus Sharp, this court also said that there should not be hard and fast limits for investigatory stops. And that's what happened here. Those 7 to 8 minutes were a second stop after the traffic stop had ended, an investigatory stop began. And according to Illinois versus Caballas, this court said that is allowed, that could happen. The traffic stops can turn into investigatory stops. That's what happened in Branch with that 30-minute continued detention. It was a traffic stop that turned into a narcotics investigation. That's also what happened in Arizona versus Johnson, where the court said that lawful roadside stops begin when there is a traffic violation, and those stops are reasonable for the duration of the stop.
How long could this stop have feasibly lasted? Could Officer McLean have taken the stop another 30 minutes? What if backup wasn't anywhere close to the scene? Could it be another hour?
Your Honor, this court has said in Sharp that there should not be hard and fast limits, but there have been circuit court cases that have been held for much longer. There was one in the 8th Circuit, United States versus White, that said that 1 hour and 20 minutes waiting for a drug dog to even appear on the scene was reasonable.
Shouldn't we balance the officer's concerns to get backup at the scene with Mr. Harmon and Mr. Morgan's Fourth Amendment rights against unlawful search and seizure?
Yes, Your Honor. Here, there was not an unconstitutional seizure. It was a very reasonable stop. According to Arizona versus Johnson, this court said that police are allowed to perform administrative investigatory activities at the scene of a traffic stop. And yes, Officer McLean was waiting on backup. She called it, though, she called for backup before she even issued that warning citation. And she waited for a good 7 minutes before she went and issued the warning citation to Mr. Harmon and Mr. Maida. It was a very reasonable act on Officer McLean's part as an officer by herself at night. In the middle of the night, she was outnumbered by the passengers, to call for backup and to wait just a few minutes.
Isn't that even more problematic that she waited 7 to 8 minutes before issuing the citation and then another 7 to 8 minutes? Isn't that almost delaying? And that's even worse. Now we're not only 7 to 8 minutes of a violation of the Fourth Amendment, but now we're up to 15, 16? That's pretty absurd.
No, Your Honor. Those 7 to 8 minutes before she issued the warning citation were still very valid and part of that traffic stop that is held as reasonable in Illinois versus Caballas. But the 7 to 8 minutes after the traffic...
In Illinois versus Caballas, can you give us the breakdown of the timeline of what happened in that case from pulling the car over to the dog sniff and the
Yes.
traffic violation.
Yes, it was about 20 minutes in length, and there were 2 officers and a dog in the car when the first when they were pulled over to begin with. So while one officer was writing a warning citation, the other officer was performing the dog sniff. That Officer McLean did not have that luxury in this case. She had to call for backup before she performed the dog sniff, just to be safe. And officer safety is a valid reason, but those 7 minutes were de minimis, no less. Cabayas said that
De minimis under what standard, Counselor?
De minimis under what standard?
Yeah, I mean, 7 to 8 minutes may be de minimis to you, but 7 to 8 minutes of a total stop of 20 minutes or 28 minutes, that's almost 25% of the time. So that's not that de minimis.
Especially when you're sitting at a roadside with an officer, it feels like hours.
Yes, Your Honor, but like I said, the United States versus Sharp, this court said there shouldn't be hard and fast limits when there are investigatory stops. We should be able to give officers leeway when they're making these stops to investigate further, even if it's just a little bit. Cabayas said that conducting a dog sniff wouldn't change the character of a traffic stop that's lawful at inception and otherwise executed in a reasonable manner.
But again, in Cabayas, the traffic stop ended and there was nothing after. Once the violation was given, the dog sniff had already been completed. Aren't we just allowing officers to drag out this traffic stop for as long as they want until they find something?
Why don't we just park police cars on the side of the road and stop every car and just search them?
I'll answer your questions in turn. Chief Justice, in Chambers versus Maroney in 1970, this court said that officers cannot hold citizens over for an indefinite amount of time to search their vehicle, and that's not what happened here. That was the inside of a vehicle. Chief Justice, I see my time has expired. May I finish answering your questions?
Briefly.
And Justice Maida, can you repeat your question?
I was saying, why don't we just park a police car on the side of the road, and then if it's midnight and someone's driving at 10 and 2 and nervous, we could just stop them.
No, Your Honor, there must be reasonable suspicion.
Well, I mean, that's the reasonable suspicion in this case.
Your Honor, there were many factors that amounted to that reasonable suspicion, and United States versus Cortez lets us look at those in totality. Thank you.
We hope that you enjoyed that, and we also hope that it gave you a good opportunity to see what it's like at the appellate level before a panel of judges. Now, I'd like to give you some information about Moot Court Spring 1L competition. This competition serves as our Moot Court tryouts. We will invite the top scoring competitors to join the society as a 2L. Now, before I begin, I'm going to give you all a lot of information, and not to worry, don't worry about writing anything down. This all will be emailed to you by your LRAP professor this evening. The competition begins on Wednesday, April 1st. You can start registering today through Monday, March 23rd. To sign up for the competition, again, you must register. This afternoon, your LRAP professor will email you an information packet plus 2 forms. The information packet gives specific information about the competition, including rules and deadlines. Read it thoroughly so that you know all of the information. Now, again, there will be 2 forms which accompany the packet. The first form is a registration form. Fill it out and email it back Monday at 5 p.m. This is a very firm deadline to register to compete. Again, all this information will be in the packet. Also, where to email your application will be in the packet as well. There will also be specific instructions on what to name the document entitled the email subject line. On the registration form, I will ask you to list any 2L or 3L Moot Court members with which you may have a conflict with, and I will make sure that they do not judge you in any of your rounds. The second form you'll receive is the schedule conflicts form. If you have any conflicts, you must send that back to me as well, Monday, March 23rd by 5 p.m. In the information packet, you'll find my email address, which you are free to use at any time if you have questions. I will be your go-to person for this competition. Please use the 1L competition Gmail address to submit your registration and your forms. So you'll see two emails, one my direct email and another email which you will only submit your registration form and all the other attachments as well. Your LRAP brief will be used for your 1L competition. If you participate in the competition, we will retrieve your brief from your LRAP professor. So basically, you all have already submitted your brief. I highly encourage everyone to register. My perspective is that there is no loss for registering for the competition. All you have to do is send in the brief form. Again, as Darrell stated earlier, we hear stories every year about 1Ls liking the oral argument process of LRAP, but unfortunately by then it's too late to register for the competition. Also, you have an opportunity to win some awards. We give out awards for Best Brief and Best Oralist. As far as the competition schedule, the information packet has specific dates and time for each round. Again, the competition will start Wednesday, April 1st, and go through April 10th, Friday. You have 3 rounds, but in the very first round, the preliminary round, you will argue both on and off brief. So just to clarify, on brief is the brief that you all wrote for your LRAP professor, and then the off brief side, you will argue the opposite side. I will make all of these briefs available to you online, so what we suggest you do is go online to look at the opposite side, which then you can form your off-brief argument on. If you have any conflicts, please use the form that I will send and clearly designate the specific dates and times you will be unable to argue. If a conflict comes after this Monday, March the 23rd, it is your responsibility to contact another competitor, have them switch with you, email me, and CC the other competitor so that I can be aware of the change. We encourage you all to talk to members of their experiences in moot court. We and other society members will be here around the demo, after the demo, if you have questions. But you are absolutely not allowed to seek any help regarding this competition. That means advice on what to do during an oral argument or practicing with any moot court member is prohibited, which would pose, of course, an unfair advantage. You are encouraged, though, to practice either on your own or in groups. Now, before we conclude, I'm going to pass the mic to Professor Ann Rector for some concluding remarks. Thank you.
All right, I'll keep this brief. 4 things, but brief. First, completely unrelated to what you just saw. As you all may know, I'm the director of the Tiger program here at Emory Law School, and we're having an information session tomorrow, Thursday, at 4:15 in classroom 5E. So if you're interested in Tiger, you can always shoot me an email or call me or whatever in my office. But if you would like to come tomorrow, it's 5E 4:15 upstairs. Okay, completely unrelated, but I had the opportunity to tell everybody that. Second, your own professors will post sign-up sheets for your own LRAP oral argument at their offices. Those are March 27th and March 29th, in case you've forgotten, in the midst of visiting day weekend. Hey, let's just go crazy here. So look for those. They'll be giving you information about signing up for your own oral argument for LRAP. And on your way out, if you didn't sign in today on an attendance page, please do that. They're still outside the auditorium, so we want to know that you're here if you were here, so you get credit for being here. And before you leave, let's give our entire moot court group another round of applause. Thanks.